We're now going to debate something that is very important to all of us, which is the Code of Conduct Tribunal and the Code of Conduct Bureau. And this is something that sits very well with one of the main agendas of this conference, which is the rule of law. Before you is a distinguished panel that will begin to x-ray the issues that have come up lately about this tribunal, whether it is a judicial body, whether it's a regulatory body, whether it's a member of the executive, or is subject to directions of the judiciary. Time is very much against us, and we would try to ensure that we're out of here within an hour so we can get to lunch. I'm going to start with the special one amongst us. Oh, not you, Mrs. Rabana, but I'm going to ask Nella Rabana to open the floor. Nella Rabana used to be Attorney General of Cross River State. She's principal partner of Lex Global Partners. Ladies and gentlemen, let us welcome her.
Thank you. Just so that I won't appear to be an impostor, the notices show that I am principal partner of R.A. Rabana & Co. And that's my husband, but I'm actually the principal partner of Lex Global Partners. I'm told I have only 7 minutes, and I would start by saying that thanking, of course, I still need to thank the organizers, and that the fact that this topic is critical. It's critical because in resolving it, it transcends the rule of law, separation of powers, the Constitution, and therefore it should touch the hearts and minds of all of us lawyers, since our motto is to promote the rule of law. I had spoken about and I hope that you would find time to check and see that the slides have been made available, and it covers sufficiently the areas I have spoken about. But in answering the question, what I did was to look at the nature of the CCT, that it is a tribunal, that it has quasi-criminal powers, that it is not a superior court of record, and that the members are not judicial officers. The reason I had to do this was because it is necessary, and of course with judicial pronouncements on it, that we actually see that this is an administrative, even though it's adjudicatory in nature, it is an extension of an executive, a federal executive body. Now, before now, it hadn't really been an issue. I believe the reason why we are having this great debate is because a judicial officer was arraigned before the tribunal. So the question now is, can a judicial officer be arraigned before a tribunal? In my opinion, ordinarily there shouldn't be a clash, because the ordinary meaning of the provisions are clear. But where it appears to overlap, because the CCT has powers to try public officers, and judicial officers are listed as public officers. Yet, the NJC, which is also a federal executive body, but created after the CCT and for the singular purpose of trying, or rather, of appointing and of exercising disciplinary control over judicial officers, and also exclusive control over its funding, which was mentioned briefly. It shows that this is a body that was created strictly for the business, the management and control of the affairs of the judicial officer. And it also enforces and enhances and enshrines the fact that the judiciary ought to be independent. But some schools of thought have tried to separate the Nganjiwa case, which is a Court of Appeal decision, because they say it has to do only if it is the cause of a corrupt practice and whatever else. And that cannot be correct because of Section 292, which guarantees the tenure of judicial officers. If anything enshrines the independence of the judiciary, I believe it is that section, because it clearly states how you can remove the head of courts of superior courts of record, and it also shows that apart from a president or a governor who must have two-thirds, two-thirds must support the information to the president, it's only the NJC. And we have cases. Elelu, Habib, and Nganjiwa have not been there's been no adverse decision by a superior court, by the Supreme Court. Therefore, that is the law. So as to the question, is there a clash? I feel there isn't a clash, but by virtue of the fact that the two bodies have now been brought into contention, it will appear that it must be resolved, which is why in my recommendation, I said one, that maybe, well, first and foremost, the Supreme Court should take the next opportunity, because in the case of Onagen, I, along with the team, filed a matter at the Supreme Court, and based on technicality, the Supreme Court did not go into the merits, but the idea was for them to pronounce even further, affirm what it is, so that there will not be loopholes that will enable us abuse and violate the Constitution and also violate the rule of law. It's important, I think, for me to mention that the hierarchy of the CCT also is of critical importance, because the abuse of subsisting court orders happened because the jurisdiction was assumed where it ought not to have been, and there even appeared to be confusion whether or not the tribunal was a superior court of record, or in fact whether it was coordinate. The fact that its appeal lies as of right to the Court of Appeal and Section 246 does not make it a court, it does not confer it with the inherent powers of the superior court of record. More particularly, the Superior Court of Records are only 9 and have been listed, and even where C65J allows you additional courts, the National Assembly to enact laws that will increase that number, it has not happened. So there's no way the CCT would be one of those, would assume the jurisdiction of a superior court of record, and it also has to respect any court order, because the superior courts of record have as their inherent power the power to supervise, and that supervisory power of the Federal High Court and the High Courts and that of the FTC is very, very clear. So for us as lawyers, I think my third recommendation, apart from the fact that the CCT law, the Constitution should be amended to allow the CCT refer, in the event of an allegation, refer such to the NJC, because the law is subsisting that is the first port of call. Since that is the law, unless the Supreme Court otherwise pronounces, it should just refer. And if you really look at Nganjiwa, it says that the NJC is empowered. It has professionals, and they can refer. And I think I also need to go to 292 very quickly to say that the 3 grounds upon which you can remove a judge has been stated very clearly. It's either incapacity to do the work because of an infirmity in the mind, or body, or gross misconduct, and the code of conduct. So for the Constitution to even recognize that that is a ground which the NJC can address, I do not think there's a clash. I think that we as lawyers should speak in a collective voice to say, to remind ourselves and remind those who we lead, and also to influence and to protect the rule of law, good governance, nation building, and of course the independence of the judiciary, by lending our voice to the fact that the law as it stands today is based and predicated on separation of powers, and the independence of the judiciary is important, and that judicial officers should not be exposed to threats, intimidation as a result. Thank you.
Thank you very much. I think you deserve a great round of applause, being able to put in so much in 7 minutes 45 seconds. Because you're a lady, you get more time than all the men. So, Chief, you're going to get least time. So we've heard from Mrs. Andem Rabana, and she's gone into the philosophy and lays a good ground framework for the discussion from the point of view of what happened to the CJN. So I'm going to ask someone who is likely to take a contrary position, Rotimi Jacobs, who is principal partner of Rotimi Jacobs and Co., to let us have another perspective. So, Mr. Jacobs, you have 7 minutes. Thank you.
Yeah, the chairman of this session. I stand on all existing protocol. Now, the topic itself, the Code of Conduct Tribunal, a clash of judicial and executive power. Well, I don't know the source where we got that, the clash. Because if you look at the Code of Conduct itself, the Code of Conduct Bureau and the Code of Conduct Tribunal, the purpose of these two institutions are mainly to fight corruption in public places, to check corrupt practice in public service. They are mainly established to maintain high standard of public morality in conduct of government business. So their main aim is to see that the public officers conform to the highest standard of public morality and accountability. That is the OSS. And how did it start? It was in 1979 Chief Willett and Professor Wabueze recommended that we have problem. And how do we deal with corruption in public service? And when they refer to public service, it's not just judiciary or the executive. They included legislation in their thinking. So, in the legislature. So the three arms of government were intended to have a code that will govern them. And that will be able, the Constitution will be able to provide a machinery for its enforcement, so that this public morality and accountability can be guaranteed. That was the intention. But how far did they go in 1979? The 1979 Constitution provided, yes, there shall be a code, there shall be a bureau, there shall be a Code of Conduct Tribunal, but with limited power. They were given limited power. In fact, in that section, in 1979 Constitution, if a public officer admits that he contravenes the code, that will be the end of the allegation against him. So effectively, we could not prosecute one single case under the 1979 Constitution. Now, and they also, in 1989, an attempt was made that what do we do to ensure that this code of conduct is given more bite and autonomous, and they will be able to act effectively. Now, under the 1999 Constitution, they removed that provision that says once the public officer admits to the fault, then he should go home and he should not be prosecuted. So then, in an attempt to make it more effective also, they created the Code of Conduct Bureau and made it an executive body. under Section 153. It was not in 1979 like that. So it was that intention that the Bureau should be an executive body. That was the thinking that, well, since Bureau and the Tribunal go together and are created under the same act, can the two be executive body? So that is why there is this misconception that the Code of Conduct Tribunal is also an executive body. It's not an executive body. It's a clear misconception. And incidentally, they see themselves as being part of the executive. They are not. And further effort made under the 1999 Constitution is that they remove that provision, as I said, the provision of Section 3D that says once you admit, you go home. They said, no, we need to do something about it and make it more independent, the tribunal more independent. So under the 1999 Constitution, the tribunal the members can no longer be removed. They can be in the office for 70 years until they reach the age of 70. So, and similar other provisions. But the area where there is failure under that new development under 1999 Constitution was that they now have independence, so-called independence, but financial independence was not into consideration at all, because they still depend on the executive on how to run their budget and the court to build and where to go. And we still have only 3 members. And if you look at the Code of Conduct itself is so archaic because they adopted the code that were prescribed in 1978 under the 1979 Constitution. So they are neither, you cannot say they are criminal in nature or civil in nature. It's a mixture of civil and criminal. So it was left like that. So they are not, in fact, when we filed an action in 2015 in September, that case we filed in September was first case in that year. So if a tribunal is like that, with only 3 members, in fact, in some cases, at times, we have only 2 members who are sitting. So I think we need to do more to make this tribunal to be more independent. So there is a misconception that once you admit, then you go free. No, that was under the 1979 Constitution. And that was the error that the tribunal was also making. Because I remember in the case of Tinubu and Federal Republic of Nigeria, the tribunal was still thinking that their act was the one that is still regulating them, not the Constitution itself. So, and gave a decision in Tinubu's case and say, no, since Tinubu was not invited to admit or accept the breach, then the case is incompetent, and the case was thrown out. So, but when I saw the pattern, I wrote an article and I sent to the tribunal. I said, your decision did not take into consideration the new provision of 1999 Constitution. So subsequently, they changed this pattern of series of decisions and realized that it was also raised in Saraki's case, which we got up to Court of Appeal, where the Court of Appeal affirmed clearly that no, whether they invite you or not, the tribunal has the power to proceed with the case. So I think the fear is that this tribunal is being treated as if it's an executive body because of Section 153 of the Constitution. But it is not an executive body. It's supposed to be an independent body. And if you look at the mode of the appointment of its chairman, where the National Judicial Council will make recommendation to the president will make a recommendation to the president, and then before the appointment will be made, and the mode of removal. These are very strict. But without fund, without money, how would this tribunal be able to perform its function? And I think we need to review the provisions of those acts so that they can be more potent to be able to fight corruption in public service.
Thank you very much. Brilliant. Thank you very much, sir. Thank you. So we've heard, and I think it's a great thing that you went into how this all came about. And I guess for many of the lawyers in the audience who may not have been born in 1978 or 1979, you begin to understand the history And I think it's a great thing that you said, look, the reason why we have this is to deal with corruption from its very roots. The last two speakers are great writers and debaters. They're always in the press. And I hope one of the two of them will be devil's advocate for the Code of Conduct Tribunal and not speak against it. So I'm going to call on Adegboruwa Ebun, a great mind, just being preferred as a senior advocate of Nigeria. So what I would like you to do is to disagree with Rotimi Jacobs so that Chief Ozekhome can then, take another position. Thank you.
Thank you very much. I believe that the topic is relevant for our times and also for the theme of this year's conference about facing the future. There is definitely, in my view, a clash of executive and judicial powers as represented in the Code of Conduct Tribunal. And I agree with the Honorable Chief Justice of Nigeria when he delivered a speech a while ago to say that the best way you can determine the independence and autonomy of any institution is to look at its funding pattern. The Code of Conduct Tribunal has no parent, as it were. It just lies as an orphan. The law setting it up has not prescribed the mode of funding for it. That is why we think there is an executive body, because the funding of the tribunal is shrouded in some kind of mystery. Now, the challenge we have, as it were, is that the framers of the 1999 Constitution have more or less given the tribunal to the executive. The tribunal was established by the military government of General Badamasi Babangida through the Code of Conduct Bureau and Code of Conduct Tribunal Acts that came into force on January 1, 1991. And that act is still subsisting. So by the time the 1999 Constitution came into force, it just replicated the 5th schedule and reproduced in paragraphs 20 and down the same provisions of the Code of Conduct Bureau and Code of Conduct Tribunal Act of 1991, as if the Code of Conduct Tribunal was actually established by the 1999 Constitution. So there are two laws in this nation as we speak, which claim to establish the Code of Conduct Tribunal. That is the 1991 Act and then the Constitution. Now, according to the Constitution, the chairman of the tribunal must be a serving judicial officer who must be recommended by the National Judicial Council and then appointed by the president. Now, that same Constitution also gives the tribunal powers of the courts to make findings, to judge and declare somebody to be guilty or innocent. When you give such power to any institution, you must be careful to give it independence, because it is subject to manipulation, it is subject to extraneous influences if you do not give it sufficient power to determine its independence. The other two members of the tribunal, the law is silent as to how they will be appointed and as to their status, whether they can be accountants, whether they can be scientists. The law is only specific about the chairman to be a serving judicial officer. Now, the conflict is this. If you look at recent developments in our nation, some military officers were said to have shot some police officers in Taraba. As we speak today, those military officers are going through military procedure before they will come and face the regular courts. So if a judicial officer is alleged to have infracted the Code of Conduct provisions, he should be treated in that regard as a member of the judicial arm and be handed over to the National Judicial Council, which has been empowered under Section 158 of the Constitution to have total independence and not to be subject to the direction or control of any other authority. If you do that, then you have given independence to the judiciary, because by that you establish the NJC as the ultimate decision-making power in respect of any infraction by any judicial officer. Now, the Code of Conduct Tribunal, however, says that the decisions of the tribunal would go directly to the Court of Appeal. I believe from the provisions of the Constitution and the Code of Conduct Tribunal Act, that body should be an inferior tribunal. When you join artisans, scientists, when you join people who are not trained in the legal profession to somebody who is a judicial officer, their decisions should not be equated with the decision of a superior court of records. So in that regard, there's clearly a lacuna in the Constitution, and the Code of Conduct Tribunal presently is flying in the air because the source of its power is dual. Is it established by the Tribunal Act that was made by the military in 1991, or is it established by the Constitution? There are other agencies that the Constitution has recognized and preserved. Under Section 315 of the Constitution, the NYSC, National Youth Service Scheme, the National Securities Agencies, the Land Use Act, are just put in the Constitution and protected without replicating the sections or claiming to be the one that established the NYSC or the NSA. So the Constitution is telling a lie against us to say that it has established the Code of Conduct Tribunal, whereas there is another act that was made by the military. And that is the reason why we are having challenge with the Code of Conduct Tribunal. It was conceived by a military regime to be an agency that can be used to try corrupt public officers without the necessary equipment and knowledge that it should be a judicial institution that should have independence. So the solution, therefore, is to ensure that we amend the Constitution to ensure that only judicial officers are members of the National Judicial Tribunal. And that way, we can guarantee their independence and autonomy. Thank you very much.
Thank you very much. I think the debate has kicked in, and I see there is popular support for the judiciary here. And Mr. Jacobs, you're going to have a lot of time. I hope Chief Ozekhome is going to start by demonstrating that the Federal High Court, which was created by the Federal Revenue Act, 1973, is also in the same nebulous position as the CCT because it's also mentioned in the Constitution. So, Chief, within your 7 minutes, can you start from there? I know you're going to take on the CCT, but start from there first.
Thank you, Mr. Moderator. Let me quickly disagree with Mr. Rotimi Jacob, Senior Advocate of Nigeria, on the ground that the CCT as it is today is actually an appendage of the executive, nothing more, nothing less. Indeed, when the Justice Onege matter came up, the chairman of the CCT, Mr. Honorable Danladi Umar, mind you, not justice, because he's not a judge of a superior court of law record in accordance with Section 6, subsection 5 of the Constitution. When he was queried by the NJC and the National Judicial Service Commission, he told them straight away, I'm not a part of you. I'm a part of the presidency. So we have a peculiar situation here of the CCT being a bat, being like a bat. The bat goes to hold meetings with the animals. When they see him, They say, what are you doing here? You are not an animal. You are a bird. He said, no, I am an animal. You can see my long ears. You can see my teeth. You can see my mammary glands. I am one of you. After that, he will go and hold another meeting with the birds. And the birds will say, what are you doing here? You are a mammal. He said, no, I can fly like you. Let us fly. So the CCT, which was set up in January 1991 to actually deal with corrupt matters, has enormous powers. It can remove, it can order vacation from office any member of the legislature. He can even ban them from holding office for 10 years. Then he can also order forfeiture of the properties of such a public officer. Such a body must be subjected to internal mechanism control under the NJC, which it is currently not. You must look at the provisions of sections 153, 158, 291, 292, and the first schedule, parts A and B of the Constitution, to see that the NJC as an independent body is set up to control courts of law that can give judicial decisions. The CCT has onerous or awesome powers to punish people, but without being subject to this internal judicial mechanism. In Saraki against or Federal Republic of Nigeria versus Saraki, Justice Onoga himself made it clear that yes, it is correct that the CCT has quasi-criminal powers to punish, but that does not make it a court of superior record. For you to know a court of superior record, you must have recourse to Section 6, subsection 5 of the Constitution, ranging from the Supreme Court of Nigeria, the apex court, to the lowest court. Now, the question is, how can such a body not be under the control of an organ? What we have seen here is that the CCT is a body that has imperious powers, but not subject to any control of anybody. To make matters worse, the Constitution says the National Judicial Service Commission can be in charge of its termination and the termination of the appointment, but the NJC cannot. So that places the NJC in a precarious position, that it is totally castrated as regards the powers of the CCT. Of recent, the Court of Appeal, in the case of Justice Onoga against the CCT, against the FRM, two decisions that emanated from it. Mind you, almost 3 months after those cases were argued and after the harm had been done, they made it clear that the CCT was subject to judicial review by the Federal High Court and High Courts in Nigeria. Contrary to the earlier position taken by the CCT, that it was not subject to decisions or to orders of the Federal High Court or High Court or National Industrial Court. Because of that, many orders were made against the CCT to stop further hearing of Onoga's matter, very imperiously, like Louis XIV of France, that will stand in front of Parliament to beat his chest and say, "L'État c'est moi, I am the state." The tribunal said, "We are not going to obey your order." And because of that, they went on to roast the man. In any case, in any event, we must realize at the end of the day that no power, howsoever great, when untrammeled, it will lead to certain abuses. That is one thing we have been saying. And the CCT itself, the setting up under Section 20 of the CCB-CCT Act, which was also exactly replicated in the 5th Schedule, Part 1 of the Constitution, violates the doctrine of covering the field. You cannot enact in an act certain provisions that have already been covered by the Constitution. What it means is that for you to unbundle the CCT, you must amend the Constitution in accordance with Section 9, not that of the CCT. So we are having a body that is less, not just less than perfect, but that is actually on a rampage. In Tinubu's case, the CCT said, we could not hear this matter. In Justice Nguta's case, they said we could not hear this matter. Section 3 of the CCT Act makes it clear, 3D, that when a public officer, a judicial officer, says, I made a mistake in my declaration or no declaration, he says, the CCT shall not go further in the matter. Is here. And under Section 3E, he says, it is the CCB that will prescribe to the CCT whether a matter should be brought before them. So the decision in Saraki's case never overturned that provision. In fact, the decision in Saraki's case by the Court of Appeal, cited by Rotimi Jacob, as senior advocate of Nigeria, was actually overturned by the Supreme Court. So the position today is that the CCT, though having enormous judicial powers, is not a superior court of law. It is an inferior tribunal. No question about that. I just want to end my speech by saying this. You see, this is to tell the judiciary, members of the judiciary are here, judges. Listen to this carefully. Please do your job, fear justice here, even if the heavens will fall. The reason is simple. When you throw a stone into the market, you will never know where it will end. It was in Martin Nemola. Finally, yes, sir.
Thank you, Chief. Chief,
yes,
thank you.
In 1946.
Chief, hold on 1 second, Chief. 1 second. Chief is a great believer in the rule of law and fundamental human rights. And he loves women's rights more than anything. She spoke for less than you have. So thank you, Chief. So the point is, Chief failed, although you are clapping for him, because he did not answer the point made by Ebun Adegboruwa that the CCCT is a problem because it's created by statute and created by the Constitution. And I asked Chief to answer whether the Federal High Court also has the same problem because it was created by the military, by Gowon. It was created by Gowon, Federal Revenue Court. Okay, my memory fails me, but this is, no, Chief, you will come to you. It's okay.
It doesn't have that
Chief,
problem.
hold on. And from Chief, we now know that CCCT is a bat. And we know from him also, from his writings, that he has reversed himself on his position on CCCT. But we're going to open the floor to questions. But before that, Mr. Rotimi Jacob's essay on, because it seems that, he says they should roast CCCT. And since you speak for the body, before you are roasted, I think it's useful if you speak for 1 minute on the Saraki case, which he says was, has come to a different determination. And then we'll open questions to the floor.
Well, I can understand Chief Michael Ozekhome speaking on the side of the defense, and the defense side is always popular. And Mr. Adegboruwa also is always a defense counsel, and they are also popular to the Nigerian public and particularly to our colleagues. Now, there is a clear misconception as to this CCT constitution. It is not true that it was military that set up Code of Conduct Tribunal. I have made this point clear that it was in 1979 that this thing came up. Chief Everett Williams and Professor Nwabweze, they are the people that said, no, let us have this body. So it is not true that it was the decree of 1991 that came into force in 1991 that established it. No, that is not true. And the Constitution is there before 1979 Constitution. And the 1999 Constitution, my colleague was saying that where the tribunal cannot assist with the act of military and the Constitution, everybody knows that the Constitution is superior. This act was recognized by Section 315 of the Constitution. After the enactment of the 1979 Constitution, the act will be read in conjunction with the Constitution and subject to the Constitution. So the aspect that Chief Ozekhome is talking about.
Thank you very much.
Talking about the repeal enactment.
Thank you.
That aspect is a repeal enactment.
Thank you. So we're going to take questions from the audience. I'll stand because I can't see very well. Chief Olanipe, can we get microphones? Chief Olanipe, Senior Advocate of Nigeria. Please, the questions must be 30 seconds. I would, please, 30 seconds. Microphones, please. Prince Ajibola, can we have microphones? Can you?
Mr. Moderator, please, I will just, let's go straight so that we can get some things clear and clearer as lawyers. One, I don't agree with my learned colleague, Ebun, that the Code of Conduct Tribunal is under two statutes. There is a Constitution. When the Constitution has made provision for certain matters, the Constitution covers the field, the doctrine of covering the field. You can check AG Federation against AG Abia, INEC and Musa, as simple as that. Then I also don't agree. We have a lot of problems in our hands. It is not a question of the prosecution against the defense. It might be me today, it will be somebody else tomorrow. We have to sanitize the criminal procedures in our country. And all decisions of the Supreme Court went to refer that by Ademola CJN, that however powerfully constituted a tribunal might be, it should not be invested with criminal jurisdiction. This is the problem we have in our hands. And we now have a situation whereby a tribunal that is not reporting to anybody, reporting to the secretary, to the government or the federation, will say, I order that your property be confiscated. I order that you vacate your office. It does not augur well for the nation. And this is my counsel to my learned friend, Rotimi Jacobs. It's not a question of prosecution, no. Let us remind ourselves, and I will take my seat.
Thank you, Chief.
In 1980 or thereabout, the sugar buyer was deported. A commission of inquiry, tribunal was set up, headed by Rikefe, JSC. Adefila at Maiduguri gave an injunction restraining the tribunal from sitting. Rikefe boarded a flight from Lagos. He landed at Maiduguri. He wanted to start his job. He heard on the radio that an injunctive relief has been made against his tribunal or committee. What he did, he turned back. He boarded the next available flight. He said, I will obey the order of the court. Now the question is this: will the Code of Conduct Tribunal obey a positive order, a binding order, an extant order, an existing order of a court today?
Thank you, Chief.
We are in very serious trouble.
Thank you very much, sir. No, madam, not you. Any lady in the hall? Any lady? I can't see any lady. Can we give mic to, no, not senior advocates, please. Any lady? Can the microphone be given to any lady that likes to ask a question? No? Well, the gentleman there, yes, please, can he be given the microphone there? The gentleman in the white tie. Mr. Jacobs, please be ready to answer, Chief. And Ebun, yes, 30 seconds each. Lunch is just 12 minutes away.
Good afternoon, gentlemen. May I be permitted to stand on the existing protocol? In as much as I appreciate the argument, I would have loved a situation where lawyers, since we are taking up the future, we should be proactive, not be reactive, one way. And then, sir, my argument, in as much as I align myself...
Please speak up.
In as much as I align myself with the submissions of Mr. Jacob and the first speaker, this is an issue the Constitution has taken care of. That's one. Number two, there was a binding, a kind of decision by the court recognized by the Constitution. I think the best thing is we test the position of the law in the courts.
Sorry, we
not
can't hear you.
An academic exercise.
Malam Yusuf, sorry, thank you. We heard you. Malam Yusuf, can we move the microphone here?
Thank you, Mr. Moderator. Please, two gentlemen, two issues.
Malam Yusuf, two questions, no commentary.
Thank you.
Questions only.
We must address the problem of judicial timidity. It's very important. Very, very important. Number two, we all seem to forget the historical basis of the CCT. The CCT, to me, is no more, except for it's been mentioned in the Constitution, it's like the professional disciplinary bodies of the MBA, of the legal practitioners and medical practitioners. And that is why we seem to forget a body that has no criminal ability to sanction anybody criminally. For example, in the provisions of the CCT Act, it says that if it finds that an offense has been committed by somebody who has been found liable, it must refer the trial of the person to a court that has the jurisdiction and competence. So, and a body that cannot convict anybody, why does he have power to grant bail and refuse bail? Lawyers, put on your thinking caps. Thank you, Mr. Chairman.